Hello friends, welcome back again. My name is Vaibhav and we'll be discussing the second module under criminal law. And as we discussed previously, we discussed the basic principles of criminal law in module 1. The second module is based on uh, offences against human body. So let us come to specific offences which we need to discuss for the purposes of CLAT examinations. We'll be dealing only with the important, all those important offences which are usually asked in the principle and factual based questions and problems in the CLAT paper or any other law school entrance examinations. Let us start with the first offence, which is quite in news these days: sedition. Now, what is sedition? Sedition has been defined under section 124A of Indian Penal Code. Now, sedition is anything, any words spoken, either spoken or written, signs or any visible representations, which brings or attempts to bring hatred, contempt, or dissatisfaction towards the government established by law in India. Any such act on the part of a person would amount to sedition. Now, this is a very draconian law because the punishment prescribed for the offence of sedition is life imprisonment, of fine or imprisonment up to 3 years, or fine or both. So usually this particular offence was used to curb down the revolutionaries back then, back during our freedom struggle, but this has still been kept in the statute books and is being used to curb free speech and free expression. So the first we discussed is sedition. So sedition is words either spoken or written, or visible representation, or any sign which brings or attempts to bring any hatred, contempt, or dissatisfaction towards the government established by law in India. That would amount to sedition. However, what needs to be focused here is that honest criticism of a government do not come under the purview of sedition. We may, because since we live in a democratic setup, we may criticize the government. Lawfully, we may show our dissatisfaction towards the working of the government. But if we try to bring in hatred among people or contempt into the people against the government, that kind of act on part of a person would amount to sedition. We come to unlawful assembly, because unlawful assembly, riot are two offences which are quite interrelated with each other. Now, unlawful assembly is an assembly of 5 or more people. So, if the first requirement for an unlawful assembly is a gathering of 5 or more people, where the common objective of those 5 people is to by criminal force or show of criminal force to overcome the parliament, the legislature, the central government or the state government, or any public servant who is exercising his right or is exercising his lawful duties and rights, or resist any execution of any law, or commit any offence like mischief, trespass, or any other criminal offence. Or the common object is to compel a person to do something which he is legally not required to do, or compel a person to do something which he is legally required to do. So here the basic thing is, you force someone to do something or you force him not to do something. The last object, the fifth object, the common object of this group of 5 people, is either by criminal force to obtain the possession of any property, or deprive anyone of his right of enjoyment of his property of way, water, or any other incorporeal right. So if the common object of those 5 people is any of these which we discussed right now, then that assembly, having any of these 5 common objectives, would amount to be an unlawful assembly. Now, the moment force or violence is used by any member of an unlawful assembly in furtherance to their common object, then that unlawful assembly turns into riot. So, an unlawful assembly, force used for common object, becomes riot. So this is as simple as this. So once force or violence is used by any member of the unlawful assembly for attaining the common object, it becomes riot. Now, as to what is affray. Now, simply understand, affray is when two people fight in public, which leads to breach of public peace. That is an offense of affray. So if I and you start fighting in a street, in an alley, which breaches the public peace, we would be prosecuted for the offense of affray. Now, a relatively very new offense under section 195A has been incorporated under IPC, that is threatening to give false evidence. Now, this section says or lays down that whoever threatens another person or any person in whom that person is interested. For example, if someone threatens me or someone threatens one of my family members in whom I am interested. So this is the other example of pressurizing or intimidating me. So whoever threatens another person or a person in which such other person is interested in with injury to the person, reputation or property, where the intent is to force me to give false evidence in a court of law or in any criminal proceeding against you. So this offense is again punishable under IPC as threatening to give false evidence. Now we come to culpable homicide and murder. Now this is one section, one area which is a little tricky to understand. Howsoever, it is very important for the purposes of examinations because a lot of questions usually is asked from this area. Now we need to understand what is culpable homicide. Culpable homicide is the killing of any human being by another human being. So if I kill someone, that is a culpable homicide. So culpable homicide is the genus and murder is the species. So culpable homicide is the bigger circle. Murder is very few instances inside culpable homicide which we can call as murder. So this is the basic understanding or basic difference between culpable homicide and murder. So once you kill another person, that would definitely be culpable homicide. But whether it would be murder or not, for the purposes, for legal purposes, that will be ascertained by looking at the criteria for murder. Now, how do we determine, or what are the criteria of determining what constitutes culpable homicide? Now, the first important thing under culpable homicide is the intention to cause death. Now, intention, again, we discussed in our first module itself that where the consequence which you seek to achieve is death. The consequence if I am seeking to achieve out of my act is death, that is my intent, that I intend to cause death of the person I want to kill. So if there is intention, then the first requirement is fulfilled. The second is intention of causing such bodily injury as is likely to cause death. Now this is a little, a relatively milder provision whereby I have a little understanding of the situation that my act, I want to seek a consequence that there will be death, but I'm not very sure that it would definitely lead to death. But uh, it is likely in circumstances that it might cause death of the person. So the injury must be likely to cause death and should be done with the intention. An illustration of this could be that if I give a blow with a lathi on someone's head, it is likely that he might be killed. But it is not definite in this situation, though I am doing it with an intention of killing him. The third portion is the knowledge that such act is likely to cause death. Knowledge is awareness of the consequences of the act. Now, this is again a very weaker term of intention. So, I have a knowledge that striking someone on one's head with an axe will kill or usually kills someone. So, I have this knowledge. So, knowledge also imputes criminal liability of culpable homicide upon one person who is being tried for culpable homicide. So there are three things which we understood. The first is intention. The second, intention plus likely to cause death. The third, knowledge that it will cause death. So these are the three things under culpable homicide. Now there are certain explanations that has been given in the section itself. Like for example, any person who accelerates someone's death, who is suffering from some disorder or any disease or any bodily infirmity. So the best example to understand is of euthanasia. You must have definitely read it in papers, newspapers or articles in a magazine. So if, say for example, if some person, say a doctor, fastens a patient's death by administering him some lethal injection or by not giving him the proper medical attention, so that would not be that would not amount to murder. However, the section itself specifies that that would be culpable homicide. The second explanation that has been given is when the death is caused of a person, but by some bodily injury, but if we would have resorted to proper medical treatment, then he would have been saved. This defense cannot be taken up by the accused and he would still be liable for culpable homicide. So one cannot say that if he would have gone to a better hospital or he would have if he could have been given the right proper treatment at the proper time, he would have been saved. That does not absolve you from your liability because you caused that bodily injury causing death. So that would not be murder but would be culpable homicide. Now, causing death of a child in mother's womb is not culpable homicide, but killing the child, if any part of that child is out of the mother's womb, that would amount to culpable homicide. So these are the three explanations that has been given in this particular section of culpable homicide itself. Now we come to murder and the difference. We would understand what are the difference between murder and culpable homicide. So in culpable homicide we have 3 ingredients, whereas in murder we have 4. The first is intention. Now you would ask a question that here also there is intention and here also there is intention. So this intention part is common in both. So what if intention is asserted, if it is proved that there was intention to kill, whether it would be culpable homicide or murder? The answer is And whenever we are able to prove, or we are able to satisfy that there was intention on the part of the accused to cause death, that would always be murder. That would not be culpable homicide, but that would be murder, because these two are common in both of them. And since culpable homicide and murder, like we discussed, are part of each other, so this would be, if intention is established or ascertained, then it would be murder. The second is intention of causing bodily injury plus special knowledge of victim's special condition. Now here I have an intention to cause bodily injury, plus I also have the knowledge of the victim's special condition. Illustration of this could be that I know that the person I'm about to cause bodily injury suffers from some bodily disease or bodily infirmity, that one blow to his chest would kill him, or would definitely kill him. And I have this knowledge about the victim, yet I go ahead and I cause him injury. So that under that situation, it would not be culpable homicide, but it would be, this is a special circumstance that has been put under murder. So this would be murder. Now the third one, we come to third one, where there is intention to cause bodily injury. Intention to cause bodily injury plus it is sufficient in ordinary course. Sufficient in ordinary course to cause death. So the third is that we have an intention to cause bodily injury, and also there is it is sufficient, such bodily injury is sufficient in ordinary course to cause death. For example, if I give a blow to someone's head with a lathi, it is sufficient in ordinary course that one would die because of excessive bleeding. So such kind of act would fall under murder and not culpable homicide merely. The fourth one is an imminent dangerous act. Plus the knowledge that in all probable circumstances, in all probability, it will cause death.